Hello everyone, I'm Rong, a Chinese lawyer. Today I want to talk about what rights does a bank have as a bill of lading holder. In the international trade, a trust receipt loan under a letter of credit is a very common operation method of trade financing. The importer issues a trust receipt to the bank in order to apply for a letter of credit, indicating that the bank acts as a trustor and beneficiary and the importer acts as a trustee. However, when the importer is unable to fulfill its repayment obligation under the LC to the bank, which type of right the bank has over the goods bill of lading under the letter of credit? To this issue, there was no final conclusion in the judicial practice in China for a very long time. But this judgment provided very clear answers, clarifying the nature of the rights of a bank as a bill of lading holder when the importer cannot fulfill its repayment obligations under a letter of credit. Okay, firstly, let me explain the facts of this case. In December 2011, Liwan Sub-Branch, Guangzhou Branch of China Construction Bank Co. Limited, hereinafter I will call it the Construction Bank, and Guangdong Lanyu Energy Development Co. Limited, hereinafter I will call it the Energy Company. Okay, the Construction Bank and the Energy Company concluded a contract on trade credit line and a special agreement on issuance of the letter of credit. It was agreed that the Construction Bank would provide the Energy Company with a trade credit line not exceeding 550 million RMB. Including issuing of the letter of the credit. In November 2012, the Energy Company filed an application with the Construction Bank for issuing a letter of credit of 85.92 million RMB. For this purpose, the Energy Company submitted the trust receipt to the Construction Bank, and they concluded a pledge agreement of security money. The trust receipt confirmed that from the date of issuance of the receipts, the Construction Bank obtained the ownership of documents and goods under the above letter of credit. After the issuance of the letter of the credit, the Energy Company imported 164,998 tons of coal. After performing the obligations of issuing the letter of credit and making payment, the Construction Bank obtained the full set of documents, including the bill of lading involved. But due to the deterioration of business operations, the Energy Company failed to make payment to the Construction Bank. Therefore, the Construction Bank filed this lawsuit against the Energy Company with the Intermediate People's Court of Guangzhou City, Guangdong Province. The bank's claims are as follows. First, the Energy Company should pay off all the principal and the corresponding interest under the letter of credit. Second, the coal under the letter of credit were owned by the Construction Bank. Third, the Construction Bank enjoyed the priority in receiving payment from the disposal of the coal. The last one is other guarantors should bear the guarantee liabilities. This case went through 3 trial stages: first instance, second instance, and the retrial. The second instance court upheld the judgment of the first instance, but the retrial court partially changed the judgment of the second instance. All of the courts and 3 states supported these 2 claims of the construction bank. That is, the energy company should repay the principal and the interests under the letter of credit. The guarantors should bear the corresponding guarantee responsibilities. And all of the courts and 3 states dismissed the claim for confirmation of the co-ownership. The reason for the dismissing is that, for a legal fact, it is impossible to claim creditors' rights and the ownership at the same time, otherwise double benefits will be obtained. However, as to whether the construction bank has a priority to receive payment from the disposal of the coal under the letter of credit, both the first and the second instance courts held that it did not. But the Supreme Court supported this claim. The Supreme People's Court supported this claim on the following grounds. The basic mechanism and the practice of a letter of credit is that the issuing bank holds a bill of lading and the importer should make the payment against documents. If the importer fails to pay, the issuing bank will not release the bill of lading. So we know that the purpose of the issuing bank holding the bill of lading is to ensure the realization of its claims. The issuing bank does not have the ownership rights over the goods under the bill of lading. If the bank's right to pledge the bill of lading is not recognized, this will completely deviate from the transaction habits and the basic mechanism of the letter of credit, as well as the purpose of the transaction between the 2 parties. So in this case, the retrial judgment has improved the documentary letter of credit trading and security system, effectively solved the problem that puzzled the international trade due to the absence of rules in China.